The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, I'm Kevin O'Flaherty. I hope you enjoyed this Learn About Law video and podcast presented by O'Flaherty Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several locations for your convenience. Thank you so much for watching and listening.
Hi, this is Andrew with Learn About Law, and in today's video we're going to be talking about advanced directives and limits on guardians' healthcare decisions in Illinois. So we'll discuss what an advanced directive is, the different types of advanced directives, and how advanced directives can affect a guardian's authority over healthcare decisions. So turning 18 is a big milestone for most people, right? It typically signals the end of high school and the beginning of college, the legal right to vote, serve on a jury, buy tobacco and cigarettes, and the presumption that you are competent to make legal and healthcare decisions for yourself. So that also means in the event that you become mentally incapacitated, there may be a question mark over who and how decisions are made regarding your healthcare needs. Without a guardianship, education, advanced planning, or a mental health court proceeding, next steps regarding your medical treatment may be uncertain. So given a choice between advanced planning, a guardian making the decision, or involuntary litigation to determine your healthcare needs, advanced planning is usually going to be the way to go, right? Advanced planning gives the person who is doing the planning, known as the principal, in an advanced directive, control over what type of care or decision will be made, resulting in faster care, the greater likelihood for improvement, and less financial concern. Advanced planning and creating advanced directives can also give a measure of relief in the form of exercising self-management over crucial decisions rather than being left to the whims of chance. So let's talk about what exactly an advanced directive is. So they are written statements by you that dictate how you want a medical decision to be made by you in the event that you can't make it yourself. So legally, advanced directives are very powerful. Once made, an advanced directive is essentially a contract that even a court-appointed guardian cannot go against, even if the principal makes a directive that is, let's say, disagreeable. So what are the different categories of advanced directives? Well, first you have healthcare power of attorney. So you choose someone to make medical decisions on your behalf in the future if you are no longer able to make the decisions. In this legal arrangement, you are the principal, and the person you choose to make the decisions is the agent. The agent's power over your medical care is broad, but can be dictated by any stipulations that you place in the original legal agreement. You can change the agent, cancel the directive, or modify it in any way at any time, obviously before you become incapacitated. Next is a living will. A living will is another way for you to tell your healthcare professional how to direct your care, but it only comes into play with directing death-delaying treatment in terminally ill patients who are unable to state their desired care. There are some stipulations on the healthcare directives in living wills, such as if you are pregnant and can go through a live birth, or withdrawing food and water if it would be the only cause of death, right? So the next type of advanced directive is a mental health treatment preference declaration. In the case of mental or physical incapacitation, this declaration lets you state whether you would like to receive certain types of treatment associated with mental health conditions, such as electroconvulsive therapy, and also allows you to state your preference for or against the admittance to a mental health facility for up to 17 days of treatment. Like other directives, you can choose someone to make the decisions for you, and any directives under the agreement are legal for up to 3 years in Illinois. Finally, we have Do-Not-Resuscitate / doctor's order for life-sustaining treatment. This directive deals with directions on how to handle life-sustaining or life-saving medical decisions, basically. Let's talk about guardians' limits on advanced directives, right? So while guardians have a lot of power over the healthcare decisions for their assigned ward, there are certain limits on the decisions they have authority over. So some examples of this are going to be things like a ward who can still voice his or her opinion. So when the ward is still able to voice his or her opinion over the healthcare decision, the guardian cannot consent to treatment if the ward objects. but the guardian may still petition for involuntary treatment or involuntary admission based on the stipulations under Mental Health Code 405 ILCS. There are a number of stipulations under this health code, including time frames for various treatments, but the primary stipulation is that if the ward refuses treatment, services will not be given unless the services are necessary to prevent serious or life-threatening harm to the ward. A ward's consent, right? So a ward can still consent to voluntary treatment or admission even when under the plenary guardianship of their person. A guardian can consent to treatment for different therapies, including electroconvulsive therapy and psychoactive drug treatment for a non-objecting ward, again, pursuant to Mental Health Code 405 ILCS. Then we have agent versus guardian, right? So in the scenario of an advanced directive, such as durable power of attorney for healthcare or declaration of mental health treatment, the power of the agent will typically supersede that of the guardian. So normally the principal would have laid out the directive for the named agent, and this limits the decision-making authority for the guardian under the given stipulation. In this scenario, the agent essentially stands in the shoes of the principal, making the decision regardless of the guardian's input. So in summary, what authority a guardian has over healthcare decisions for their ward is ultimately determined by what advance directives were written and authorized by the ward or principal, and if those advance directives are not legally out of date. If there are no advance directives present, a guardian will likely make most, if not all, the healthcare decisions for the ward. Thank you for tuning in.
Hi, Kevin O'Flaherty again from O'Flaherty Law. Hope you enjoyed our presentation of Learn About Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.